Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Your hosts are Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm. Again, practicing attorneys here in North Carolina. Offices conveniently located in Raleigh, Garner, Clayton, Goldsboro, Fuquay Varina, Gastonia, and Morehead City. I'm Morgan Patrick, consumer advocate. Each and every week, we talk legalese. You may have some questions that you are facing. You may need some answers. You can always call the firm, Whitaker and Hamer, at 800-659-1186. That's 800-659-1186. And leave your contact information, briefly what the call's about. And an attorney with Whitaker and Hamer will be in touch. And you can always email the show, questions at theoutlawlawyer.com, and we'll answer them on a future broadcast. Well, we're going to go affirmative action. The ruling is in. Gentlemen, take it away.
Yeah, Morgan, here on the Outlaw Lawyer, me and Joe talk about this a lot, how we never intend for this to be political in nature. A lot of people look at the U.S. Supreme Court kind of a political way right now, right? Conservative justices, liberal justices, what president appointed the justice. And so we kind of look at Supreme Court justices in a way I don't think we ever really have in our nation's history. And me and Joe try to stay out of that. It's not really what we're here to talk about. The court is made up of the justices that are on the court, and that's the court that we have. But today, a few days ago, in the affirmative action case that I guess everyone's been talking about, it's actually the combination of two cases where the folks who brought it have a problem with how certain universities handle their incoming class, right? How they evaluate applicants with race being a factor. There's been a lot of U.S. Supreme Court cases that have allowed what's now called a affirmative action, so that a student's race, a prospective student's race, can be used in the application process. And I've had several cases go to the Supreme Court over the past, 20, 30, 40 years about that. And until recently, you could use race, right? You could use race as a determining factor in a prospective student's application to a university. So that's kind of how it was until this new opinion came down. And so now you can't. That's a short segment, right? Now you,
yeah, it was a good segment, man. You really knocked it out of the park. You still sound sad, but you did knock it out of the park.
So the court found that it was unconstitutional, which is, it was kind of interesting because it wasn't too long ago where the court said it was constitutional. But if you look at some of the decisions that led up to today, the Grutter decision was one back in, I think it was 2003. Sandra Day O'Connor was still on that court. And they made a big deal about how at that time, back in 2003, they saw fit to continue to allow affirmative action to stay in place as it comes to college admissions. But again, said it shouldn't be permanent. And I think back then, Justice O'Connor made a comment about maybe another 25 years or so. And then, then maybe some progress will have been made and it won't be needed. And so in the most recent decision, I guess they didn't even really address that. It's more of a, race just shouldn't place as much of an issue in that kind of thing.
That was a great summary, man. I don't even know what discussion is even left, man.
It was interesting. It was interesting in the decision. Some of the justices pointed out, because what came up a lot was, maybe this, affirmative action was getting different students of different races who were maybe in a lower percentile. It was giving them the extra push they needed to get into college. The argument from the other side was, hey, you're pushing some other worthy students out and you're doing it based on race. And there was a lot of Asian Americans who had filed briefs because there was an accusation that Harvard was actually using race to disallow well-qualified Asian Americans from getting in. So they argued that race was being used two ways, right? It was being used to get some folks in who maybe wouldn't have got in otherwise, but it was also being used to keep certain races out. And that was a big deal for a lot of the Supreme Court justices. But there were definitely some dissenters. But it would seem that, at least for now, until there's another case in front of the Supreme Court, that using race in that manner will no longer be deemed constitutional. So that was a big decision. I'm sure it'll be talked about quite a bit. But I don't know what you saw on that, Joe. Did you see anything else on that?
Yeah, I mean, a couple things, man. You talked about everything's politicized, right? And so you'll have the traditional folks that only see black and white, and you'll have the ones that'll champion this for the wrong reasons, and the ones that will poo-poo this for the wrong reasons as well. I think you nailed it, man. I don't think I can say definitively I don't support racism in any fashion, man. I can say that confidently. I hope you can too, Josh. And I don't want to see anybody disenfranchised based on their race, but I think what you did, what kind of led us to this point, and you kind of touched on it, seeing folks that were being unfairly discriminated against in ways that you might not have expected whenever affirmative action was originally thought up and was seen to be a necessary thing. And a couple things from the majority's opinion. John Roberts said, "Nothing in this opinion is going to be construed as prohibiting universities from considering an applicant's discussion of how race may have affected their life, be it through discrimination or as an inspiration or otherwise." So there's still going to be, people can still give their own personal experience and talk about how it's affected them. It's just not going to be. They're not going to tie that to. They said they want to tie the impact of that to that student's courage and determination, and not to that. Not necessarily just basing it completely on that. So I think that it makes sense. You can see the argument both ways, like you normally can. Anyone who's reasonable, I think, can look at reasonable arguments both ways. But yeah, like you said, man, 25 years or so, we're a little bit short of that 25-year period, but here we are, and it's pretty definitive ruling.
So I've got a question. I mean, you're saying it's a definitive ruling. Is there any other recourse for the other side here, or is this it? I mean, this is a done deal, or can they appeal? What's going on?
Oh yeah, there's no appeal.
Yeah, this is it for them.
Okay,
this is it.
Yeah, you get a U.S. Supreme Court decision. The only way you can really take it down is with you get something else in front of the U.S. Supreme Court. If you, I don't know what the fact pattern would even be off the cuff, but you'd have to come up with a fact pattern, someone who had been wronged in some way, and get this issue back before the Supreme Court. That's, and that's kind of what happened with other like big issues that you hear a lot about in the news, like abortion or anything like that. Right to die, euthanasia, any of these topics that are kind of talked about a lot, debated about a lot. There's agencies that try to find people who have been wronged in one way or the other with good fact patterns and try to push those to the Supreme Court so that the justices have a chance to give a ruling. And that's kind of what these cases were. There was a nonprofit who I can't remember their name. There's a nonprofit who kind of seeks out folks who have been denied admission, right, to universities, and they brought a ton of cases. And this session just happened to make it to the Supreme Court, and they got this ruling, which is, I'm guessing, what the nonprofit kind of wanted. But either way, there was some troubling evidence. I think the evidence about race being used as a factor to keep or potentially keep Americans of Asian descent out of colleges, I think that was pretty damning.
I think it was really compelling evidence, man. And,
that,
like you said, it was far more difficult requirements, and that's unfair, right? And that's not what anybody who drew up affirmative action intended it to be used as, and as an unintended kind of consequence there. But you talk about any kind of recourse for the other side. Harvard, who was one of the universities sued here, has come out and since said that they're going to follow the courts, they're going to comply and follow the court's decisions, and they'll be getting together in the weeks and months ahead to figure out how they're going to preserve their values, essentially. So, because diversity is big to them, and they make, and think anyone can see the benefit of diversity. And so I don't think this ruling necessarily should be taken as an affront to the concept of diversity. I think it's just, at its core, it's just about fairness, right?
Well, I think things have changed a lot. You can argue that things maybe haven't changed enough, but I think since the original ruling that allowed race to be considered, I think you definitely can see a change on college campuses, and you can definitely see a change on how people value diversity. And so I think there's definitely been change. And so you can argue maybe not enough, but I think there has been enough where schools will find a way. They want diverse student populations. And so maybe you don't check a box on your application and that counts as a point or not a point or whatever their rating scales used to be, but they're still going to find a way to achieve diversity, because that's, I think that's a pretty common goal across the board.
Yeah, I don't think we see diversity go away. I don't think that's going to be like an unforeseen consequence of this ruling. I'm with you. I think that's still going to be, and Harvard's come out and said it, right? Like, that's still going to be a primary consideration for them. It's one of the essential values that they hold. So I think that you'll still see diversity being championed, and there'll be an effort to keep places diverse. But at the same time, if you can take away, especially with respect to what the Asian students have gone through, I think it's a good thing to put them on a more level playing field.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm, where you can find the managing partners there, also practicing attorneys here in North Carolina. Offices conveniently located for you in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and Morehead City. If you have a legal question, a legal situation you are facing, and you need answers, you can always call the firm, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what that call is about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show. We'll answer them on a future broadcast, questions@theoutlawlawyer.com. We've got a lot to come on the program, so stay tuned. We're back right after this.